Today's podcast is brought to you by HLA Productions. Join the conversation on family law, true crime, and more with your host, me, Heavenly Leanne Akers. Well, hello, and welcome to today's podcast. This is Talks with Heavenly, and I'm your host. So, in the last episode we talked about with family law, it was participation in child custody battle. And in that episode, I talked about, hey, in a later on episode, we're going to sit back and we're going to talk about how pretrial and trial, that whole situation. Now, as somebody that was viewing my podcast, which happens to be an attorney that I'd never heard of before, made to mention to me and everything that, hey, you should probably do a disclaimer that you're not an attorney. And yeah, that is true. I'm not an attorney, but as somebody that is aware that you can also represent yourself as pro se, even knowing it's strongly suggested that you shouldn't do that, but it is possible to represent yourself as your own attorney, which is pro se. However, I'm not going to make an argument for that, but I will say this, though. As somebody that has ordered almost 4 years of legal custody battle and has a very close friend that happens to be an attorney, and I have also done my own book studies and research, as well as listened very carefully to my friend and also read every single document possible and understanding the procedures that are set before us. So now, understanding custody and court case, especially whenever it comes to pretrial and trial, and understanding everything that kind of goes into that. Now, I wish, and I keep saying this, I wish that there was somebody that could have been there to tell me, hey, this is how it's gonna go. Because most people, when they first get into a situation like this, the very first thing that they're thinking about is like, oh, well, I'll get an attorney. This person will be served. We'll go to court. We'll have it out, and then we're done. It is not at all that easy. So I'm going to kind of explain this from my perspective and how I experienced it, because it may not be the same in every single state. And now, if you're a person that is listening to this, you've already gone through child custody, or you know somebody that's going through child custody, share this with them. Hopefully it will help them, because I can 100% tell you that if you know somebody that is going through child custody right now, they are losing sleep. This is a very stressful procedure. This is a very stressful time. And, believe me, listening to somebody that has already went through it and has made it out through the other end, this will help. At least I hope that it does. However, for those that are listening, if you are currently going through child custody battle and you are stressed out, I personally will sit here and tell you there is a beginning and there is an end. It will not last forever. So let's go ahead and get into it. So let's say that you go ahead and hire an attorney, right? Okay. You pay the retainer. You tell your attorney, hey, this is the situation at hand. Your attorney starts asking you for information. Hey, do you have the child's birth certificate? Do you have the child's social security number? Hey, do you also have the child's other parent? Do you happen to have an address for that other parent? We need to serve them. Also, I'm going to start filing this information here soon, and then we're going to start serving her or serving him, her or him, either one. And they're going to have X amount of days to respond. So I'm going to go file a motion to enter. And then I'm also going to file a motion for appearance. So that means that your attorney is going to file to appear on the behalf of you as your attorney. Okay. And then after that happens, your attorney is going to serve the other person. And once that service is done, then what ends up happening is that you initiated the lawsuit. So there's two different parts to it. So there's child custody battles, which are still considered lawsuits. You're basically suing for parental rights to say like, hey, I deserve custody, visitation. I deserve this, blah, 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 because I am the rightful other parent. Now, in our last episode, we talked about what happens if you're an assumption parent, if you're married or not. If you did not listen to that episode, I suggest that you do. It will also help you understand this a little bit more. So, depending on your situation, if you are married, you'll be filing with a divorce with minor child. If you are not married, you will be filing custody, visitation, and paternity. And that also depends on your state and how your state's legal system is built whenever it comes to child custody. Now, in my situation, I wasn't married, so I had to file for child visitation, child custody, visitation, and paternity. And so once the other person is served, they have 30 days to respond. And in most cases, it could be longer than 30 days. It depends on the docket and at what's going on at the courthouse that your attorney files at. So you could be waiting a month, 30 days. You could be waiting 2 months, 3 months, 4 months, depending on when you can get a place on the docket to be seen by a judge. So once that's initiated, and your ex-spouse or ex has been served with these papers, then what's going to end up happening is they got 30 days to respond. They can either respond by calling your attorney's office and communicating to them, responding to emails, et cetera, et cetera, et cetera, or they can go out and hire an attorney. Once they hire an attorney, that attorney is going to call your attorney's office. They're going to have a quick chit chat, et cetera, blah, 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 blah. And then that attorney is going to go file a motion to appear. So they're going to enter in onto the case on the behalf of your ex, your spouse, or et cetera, to appear as their representation. Once this happens, then basically you guys will meet in court. And, you'll have discussions here and there, et cetera, et cetera. If paternity needs to be done, then a paternity test will be set up with your local DHS office or et cetera. Or it can be done through a separate party, but it has to be respected by the legal system. The legal system has to accept it. And that's just how it is. You can't just pick your own DNA lab, which is something that I was thinking I could do. But no, you can't. Now, in my situation, because my son's mother wanted to deny that I was the biological father, which is ridiculous because if you've ever seen pictures of me as a baby or even my son as a baby, we're very similar. It's kind of scary. And on the other side of that situation, right, is that my son's mother, she wanted to deny that. So the judge requested that she were to be the one to pay for the paternity test. So they took saliva from both me and my son. They did the paternity test, which, by the way, was an arm and a leg trying to get that done. We do talk more about that in what really happened in my other podcast. But then also on the other side is that you have, once she paid for the paternity test, I was court-ordered to do supervised visits until, the paternity test was done. So in the meantime, while we were trying to deal with her trying to get the paternity test done, I had to do supervised visits with my son. And those supervised visits were court-ordered to be paid, and it was $50 an hour. And so my son's mother had to pay for it. Now, you're probably wondering, Heavenly, why is it that your son's mother was court-ordered to pay for the paternity test and the supervised visits? Well, ladies and gentlemen, it was pretty much put that way because she had withheld my son from me for 18 months. So the way that the court system kind of looked at it was like, hey, the father, aka me, has already spent so much money trying to get his child at this point. So can we not, insult to injury? Because my original order was vacated because I had a default judgment. But anyways, okay, enough about that. So once basically your ex-spouse or child's other parent, either responds on their own within 30 days or they appear with an attorney, then there's going to be an initiation of stuff. And usually what would happen is like an attorney would file something called like a motion to enter. And when an motion to enter has been filed, what you're doing is you're requesting the court to grant you basically court dates. And this would look like pretrial and trial. Now, it is standard practice that the judge require that you either do parenting classes and you also will do mediation. And at this point, this kind of relays back to our past episode, which was participation. Both parties, mom, dad, dad, mom, whoever, would be required to do mediation. And now with mediation, I'm not quite sure how, I understand how mediation in perspective, like I understand how mediation in perspective works, but at the same time, my perspective of mediation is you are either in the same room or in two separate rooms, and the mediator will go to each one of you and ask you, what is it that you want? And now this ranges from, if you're married, it's property, child visitation, etc. And if you're not married and there's no property between you, then it's just child visitation. And now what will happen is the mediator will write a report and that'll go to the judge. Now, in the case that mediation fails, because in the case that mediation does work and mediation does work out, which studies have shown that mediation doesn't necessarily work out most of the time. And that's just kind of how it is. And there's a lot of reasons for that. And I kind of touched on that a little bit in our last episode with participation and child custody battles. So in this situation, you have two people that, they either have to come to an agreement or mediation fails. If mediation fails, which there's two ways that mediation fails. Number one, somebody does not participate in mediation. Number two, both parties cannot agree to anything and they are just nonstop at each other and arguing over every little damn thing. So what ends up happening is mediation either fails or it doesn't. And that goes back to the judge and both attorneys. And then eventually you go back to court and your attorneys either have to tell the judge, Your Honor, we would like to do a settlement, or we need to move forwards with pretrial and trial, or, etc. Now, in my situation, mediation failed. So in my situation, my son's mother did not want to show up to mediation, even though she kept asking for mediation, but mediation kept failing because she was not willing to participate or do it as it was necessary to do. And that's what landed us in pretrial. And I believe that my attorney filed a motion to settle is what we did. And so, I believe we filed a motion to settle. And if I think about it, so in that situation, when something is failing, then you'll have to go back to court, because at that point it's kind of like up to the judge. And hopefully you've been very forthcoming and trying to work out stuff, because if you haven't, then it's not going to look very good. Because it looks like you're just kind of like basically making a mess of the entire custody situation. I'm currently Googling something real quick. Yes, so we filed a motion for settlement, and that's where we kind of ended up going. And then after that, it was just all like, okay, well, we're going to trial and pretrial. And then let's say that you get all the way up to that point, right? There's no settlement, no nothing. You guys are still doing whatever visitation that you have, but you guys are still having issues, and you still have pretrial and trial to come. So usually the procedure for pretrial is that there's a thing called a motion for discovery and interrogatories, which is something that we did talk about in what really happened. That podcast, as well as on YouTube, which is in video form. So with that situation, you have both parties that will type up a document, and these are going to be like a list of questions, and it can be lengthy. Like, I mean, mine was like 40 some odd questions long, and that was ridiculous in itself. And so what ends up happening is that document is sent over to the other party, and then that party will send their document over to you. You and your attorney will reach out to you and say, hey, these are interrogatories and discoveries. You need to answer them to the best of your ability. And then once you answer them, do you have any evidence or substantial circumstance to rebuttal this? Because these are the questions that he or she's attorney is wanting to ask you on stand. And these are our questions that we want to ask he or she on stand, you know? So at that moment, it's kind of like, hey, your entire dirty laundry is about to be aired out, not just in front of you and your ex, but also in front of all of your character witnesses, which is another thing. You know, people that have either witnessed what has happened, our situation, when, where, and how, or family. So if you don't want your family knowing about your dirty business, they're about to find out, especially if they're witnesses to something that you believe will have such a substantial circumstance for the cause of the reason why you're asking for either a certain amount of custody or et cetera. So once pretrial comes, you will be sitting there with your attorney and whoever else. And what will usually happen is the judge can sit there and say, hey, can we try to come to a settlement today? And in most cases, both attorneys will deliberate whatever they need to, and then you guys can go into a conference room somewhere, sit down, chitty chat, try to come to an understanding. And I'll tell you this right now, on the day of my pretrial, we had a conversation, that's for sure. And I will tell you right now, because I'm looking it up on my computer. That day, we sat in there for about 2.5 hours. And it was the guardian ad litem, which is a third-party attorney on the behalf of your child, my attorney, and my son's mom, and Daniel. And for that 2 hours and 30 minutes, the guardian ad litem had sat there and heard so much information that she, at that point, realized that her choice was pretty much made up. That my son needed to be with me with sole physical custody. There was no way that we were ever going to come to an agreement because the pure amount of ridiculousness that was being said in that room was beyond. I had sat there, and as a person that is, a victim of domestic violence and abuse, I sat there and was listening to everything that was being said, and I came to the realization, like, after being away from her for so long, I then realized, like, how bad it was. I didn't think it was, like, I knew it was bad, but I didn't realize it was, like, that bad. And then I realized, like, wow, like, I will never be the same person that I was before that. I have changed mentally, emotionally, and physically as a person as a result of what I went through. But after that day, which was on September 19th, and I remember because it was my son's birthday, and I felt bad because there was no other court date, and it was, it was my son's birthday. And then the next day was September 25th, which is the day of trial. And this I have not talked about in my podcast on what really happened with Amanda Sullivan. And I'm pretty sure that me and Mandy are going to talk about it more later on because I accidentally touched the microphone. Mandy's most likely going to have her perspective and opinions, and I really want her to be able to talk about it. But I will give you a little bit of insight. So on that day, when you go to trial, it's going to be you, your attorney, your ex, and whoever witnesses are in the case. And if your ex has an attorney or not, they will be there as well. And then what will end up happening is that you will be called to do introductories. And what you're doing is there's a difference. Now, if you are pro se and you do not have an attorney, there is a difference between doing there's a massive difference between an argumentative statement and statements. So when you're making a statement to talk, to say, "Good morning, Your Honor, we are here in the hopes to bring a peace to this family," that is somebody that is coming in and saying, "Hey, you know what? We all really don't want to be here, but like, let's be honest. Like, we're coming in with an open heart. We're coming in with peace and care. We are here in the best interest of this child, our children, and we want to make amends. We want this to be a good outcome." And then when you have another party that comes in and says, "Well, Your Honor, I'm here because this person did such and such and such and such and such and such," and you have every accusation under the sun, and you want to sit there and spout all this stuff, the judge is immediately going to stop you. If you're pro se, the judge is going to stop you because, one, you're being argumentative. That is not a time to be argumentative. If you want to be argumentative, you can do that whenever you're like putting somebody on the stand and you're asking them questions and you're pressuring them because you're trying to get them to slip up on something because you know that you have evidence to rebuttal or do whatever you need to because you know that they might be possibly lying about what's happening. Now, in my situation, you have, Amanda Sullivan, my attorney. She's, I'm the first one that goes on the stand. I'm always the first because I'm the petitioner in the child custody case. So when you're the petitioner, and if this makes it to trial, just be aware you're going to be the first one on the stand. And you do have to be sworn in. I will tell you right now, Mandy will tell you this. Honey, you were a rock star. So Mandy, she's straight up. She'll tell, Heavenly's a rock star. Okay. Like this was her biggest performance. And I remember going like, it's not really a performance, because it's my life, but it felt like a moment that me being a drag entertainer really helped me try to keep my nerves still. But I will tell you this, my mouth kept getting so dry when I was on the stand because like, even now that I'm speaking into a microphone, right? I could hear myself talking through the audio in the courtroom. And it was so daunting that like hearing myself and talking at the same time is so agonizing. But anyways, so my thought is like, if you're getting ready to go to trial and you know that's where this is going and you know it's going to cost you thousands of dollars because it's not cheap, I would know. But just try to keep a level head. Try to keep yourself entertained. There's something that you can do while you're in the courtroom, and God forbid, please do not be on your phone because judges do not like that at all. So what you can do is get a piece of paper, sit there and draw circles or play tic-tac-toe with your attorney if they're okay with that. Just play tic-tac-toe. Just try to keep your nerves calm. Let whatever they've got to say. Don't let it bother you. Just water off a duck's back. Just let it be how it is. So I hope that today's episode was somewhat entertaining. I also hope that you guys like how I'm kind of editing these. I'm finally starting to edit my stuff with a professional microphone and GarageBand. So hopefully things will start getting better. Other than that, I hope that you guys enjoyed today's podcast. If you have any concerns or questions or anything that you would like to talk about, or if you want to tell me your personal story, you can reach out to me on heavenlyleanne.com, or you can comment in the comment section on YouTube. If you want to, please follow me on Apple Podcast. I will be on there as well. Other than that, I love you guys, and I hope that you have a very heavenly day. Other than that, ta-ta.